know, we have planned for 6. We may have a different morphing in the next after that to be chai or something else. But we love to have people come from the community. We have not really been advertising much. Last time we had a few people come from different organizations, which we didn't even expect. And we're glad to have you here as guests too. And yeah, we lost someone here too. And as you see, we have a lot of also our own students and workers at Hive and these guests here. And today I'm lucky to introduce a special speaker who will probably give us a lot of challenges. He's a non-compliance guy, and he's Michael Losavio. He's a JD. He's a lawyer, and he teaches criminology. So he learns a lot from these things, and he has a very interesting history. He started, I think, his career in math before he went to law school. We collaborated a lot in many things, including cybersecurity for smart cities and other things. And it's lucky to have him here. So maybe I'll not let you introduce yourself, but I'll ask you a way to tell us a little bit about what got you in this interest in cyber and AI, and what got you to drift in this area, and how did it happen? And I know lawyers like to talk, so we limit your time so we can ask you more questions.
Any one of you can hold up your hand saying, stop. You got that? All right. When I first came to Louisville long ago from DC, I hung up my shingle, but I had no money to afford a secretary. But the office had one of the early personal computers with WordStar word processing on it, and it had a DOS OS. And so I had to learn how to use it and how to program batch files for it and things that were to do my work for me, which was very interesting, much more than I expected it to be. Because when I was your age, back in early days of college, if you were doing computer science, it meant going to the computer center at 2 a.m. with a stack of cards, punched cards, that you then left. You would either wait for 2 hours to have it run, you got a printout that showed all the errors you made, or you just went home, went to bed, and came back and did it. Didn't seem interesting. And the personal computer revolution at least began to change my perspective on that. Becoming interested in it, I was got asked to teach at a local college for their paralegal program on computer applications in legal practice. And I said, sure, both because it was interesting and it was a regular paycheck. A great thing. And from that, I got to learn more about computing and all the problems that were developing within computing profession in the early 90s, particularly issues relating to copyright violations and security violations. So I talked to Dr. El-Maghrabi's department chair, and he said, well, you should teach a class on that. And so I began teaching there, got to know Adel and all of his colleagues, and things just rolled on from there.
So he started teaching our ethical and legal aspects of computing course way back, and it really was a popular course, and we appreciate that. I'll move to the next question. What is, from your perspective, about algorithmic fairness or algorithmic ethics? Is there anything you would, from your perspective, a brief definition or a way to score it in a way to say, is it fair, is it ethical, is it legal? What would be the points you'd look at?
Since we're talking about the application of algorithmic systems to human affairs, all the legal principles apply all the ethical principles apply. But devil is in the details, in that those people, when they're programming a system, don't really know what the legal limitations are. Unless they went to our department, they wouldn't have known about any ethical concerns in what they're doing. So we would also tell our students, by the way, you're working in industry, you come across an ethical or legal potential violation from what you've been told to do, don't bring it up in a staff meeting. Go talk to your supervisor one-on-one, so nobody gets embarrassed, but he is then apprised of what is going on and what you think is a risk to the company, to our users, and to his career if it blows up. Some of you may recall in the early days of Facebook that the young head of Facebook, Mark Zuckerberg, had a motto: we need to move fast and break things. Good for innovation, not good for the people that are broken by that. And so in terms of doing anticipatory system design, machine learning, neural networks, AI in general, it's very valuable to keep that in mind. But the technologists, the engineers, want to do something. They're not thinking about what the outcomes are after. And so you talked about fairness. The same as we would consider fairness in the world. Some call legally due process. Letting people be heard, hearing their objections, then trying to fix them if they deserve being fixed. The key problem with, and this is true about, I think, of any technology, but particularly with AI, nobody wants to hear, tell our students, nobody wants to hear problems. Want to implement this as fast as possible and get up and running. Deal with the problems later.
Okay. Let's move to another thing. We talked about algorithm, but then now we're dealing with what people, AI, and AI will not argue with you since you're the lawyer, we're the technocrats, what is AI. But there is a lot of AI that is a black box. So from your perspective, how do you relate these algorithmic biases to a black box that there is no interpretation, no easy judgment on is it fair, is it biased, does it violate things? How, from a legal perspective, could this be prosecuted or concerned? Or I'm building a black box. What's your perspective on that?
Buy a lot of insurance to cover your liability when it goes bad. Oddly enough, I was at a conference in India where I first heard a computer science professor from the United States was talking about this. And he said, the key issues are going to be transparency, explainability, and accountability. Transparency and explainability goes back to the black box problem. What is it doing? How is it doing it? And how do we know it's going to do something bad? Arguably, you could say, okay, fine, it's a self-trained, unsupervised model, AI, done good stuff. You should still do traditional software testing that IEEE has put out, or ACM has put out, to see if, in fact, it's doing a good job. What is the error rate output? I don't know that we do that much. Because, again, why do you want to do testing for problems? Get it into the market.
Okay, that takes us to the liability because you mentioned insurance. People buy insurance, but who is really liable? Forget about paying for it rather than worrying about it. Who is really liable in these cases of the AI being deployed? Is it the developer? Is it the data source that we trained on? Or is it the one who deploys it as a business? So there are many aspects there. The people who provided the data the developers, maybe the AI, maybe technique that was developed rather than the person who even applied it. And then there are the people who will sell it as a business. So when does the buck stop?
Excellent question. Speaking as an American lawyer, everybody's liable. We're going to sue everyone. But if you look, there is a hierarchy of liability, of responsibility, accountability. And the first, you begin at the beginning, the developers. Well, they have a responsibility. They then pass this on to someone. Then it's either going to sell it or deploy it or use it. So it's how close that developer, that programmer is to the end use that may say how much liability they have. But generally, unless they knowingly put a dangerous product in the market, they won't be personally liable. But their employer will be. That's the first person you get to. Who employed this person? Who developed it? Okay, we made it. We're now subject to liability for its misuse, its injuries to other people. Then you've got, as you said, you then put it into the chain of commerce. So the people that downstream who then take it and sell it or customize it for particular businesses, they can be equally. Then they deploy it to a business and the business uses it and they start hurting people. They then become liable. Notice they'll go back up the chain. The company will then point the finger at the person that sold it to them. They'll point the finger back at the developing company. Say but everybody's going to hold liability there, at least under American law, except in rare circumstances, because you pay.
No, but there is a layer that people have ignored, and that's why I want to challenge you again, the layer of data. Because the source that gave me the data gave me the biases and the problems that they did in the past. Are they liable? Because I'm using their biases to hurt people. My AI only extrapolated or generalized their biases and their illegal actions or malpractice actions if it's in healthcare or if it's insurance or housing or loans, it is the discrimination practices. I'm using this to extrapolate by the AI. So why should the AI be liable rather than the people who we train the AI on? And that's where the challenge that I'm always having.
Yes. Traditionally, custodian of the data will not be liable because they've just aggregated information.
Okay.
Unless they know that the data is tainted, which is a problem. If you're looking at, say, data for granting somebody a mortgage, they've known for decades that the mortgage data that was used to grant mortgages historically has been racially biased. Red lines districts is the term they use, says if you will live on this side of the line, you get a lower rate than the person who was on the other side of this line. So we know that it's tainted, but we still use it. It's part of the training corpus for an AI model.
Yeah.
And arguably, if you know the data is tainted, you shouldn't be selling it or making it available unless you have the person you're selling it to signs a waiver where they acknowledge, we understand this data has problems. We indemnify you. If you get sued, we'll pay the cost of it if it goes bad. And by the way, liability shifting is throughout the software industry. And it's I consider a really bad practice. Because whenever you say you can shift liability onto somebody else, that means you're not going to take responsibility for what your system does.
I'm a bank and I'm training it on my data and I'm deploying it. So I'm fully liable.
Yes. I have no excuse.
Yeah.
But there's the other thing I heard in India, never heard it before, but I thought this makes sense. The system for the effective use of AI is, for lack of a better term, a trinity or a triad. We always talk about the AI system up here, but as you point out, the training data is just as important. You train against bad data, you're going to get bad results. But it's a trinity. You've got the AI system, you've got the training data and utility data that it's analyzing to make a decision. But you also have what they call the human in the middle. You should never, ever let these systems run amok without a human being with understanding and knowledge of the process, looking at it and making a final decision. Best example, AI has been really effective in radiology and medicine, looking for things like tumors, flaws in blood vessels, not by itself, but when it works with a trained radiologist, they check each other. So the final results are far more accurate than they are with just the radiologist or just the machine.
By the way, about a week or 2 weeks ago, I was in AI in cardiology, and one of the famous radiologists, not from Louisville, he was Chicago, he was part of developing some of the foundation things, said, I don't want an AI that's more accurate than me. I do a good job. I want an AI that helps my job make it faster rather than improves my decision. And that was very eye-opening, that the AI is being pushed in things that the experts already know how to do, versus in areas that the experts need the help with. And but let me move to the next question.
But that's a really important point. Using it as a supplement, a complementary support, rather than relying on it solely. But I'm also worried that your doctor said, I don't want it to be smarter than me. I don't care if it's smarter than me, because if I know what I'm doing, I'm validating the work. I want better results for my patient.
And we have developed a mammography test that recognized cases that it took the second visit a year later to recognize them. 30% of them. It's not a big, but 30% was big.
Well, that was your big computer vision project, wasn't it?
One of them, projects that we published and it got recognized. But I'm not worried about this right now, but there are cases that you say that the AI could be better. We know that, but where do you put your investment? In streamlining the process, helping the doctors, helping the bankers, helping the insurance people, the educators, or put it in improving their performance? Let's go to the next one. The next one is very important, is a topic that I know you like, is privacy versus security. We give up a lot of our privacy to be secure. And secure could be mainly cybersecurity, AI that helps with the security, but we've given up a lot of our privacy. And we know there are legal differentials across the world about what is privacy. And what do you think is a balanced perspective from a user perspective or a developer perspective to view where should I balance my giving up my privacy for my security? We all face that every day.
Yes, and it's at the first level, it's a personal decision. Although a risk is that you don't understand the risks when you surrender your privacy.
Because it's a very long legal document that nobody needs.
Yeah. A practical story. He's referring to the end-user license agreement that we all say, please click to use this to go on. A couple of years ago, a software firm had an online product. And for April Fool's Day, 2023, they inserted a clause that said, by agreeing to this contract, you will surrender your eternal soul to this software company.
Everybody clicked.
Well, there was an opt-out button. Do not have to surrender your soul. But like less than 20% clicked, no, I want to keep my soul. The other said, click, off they go. And which I think exemplifies what Dr. Mulgrabi said. Nobody reads it.
But
We-
isn't that the intention? To make it more complex and lengthy?
20 pages in itty bitty type, yes. And to have every possible liability to us as the software developers and vendors exonerated. You can't do anything to us, even if our software, destroys the Western world. And that's another problem in the law generally with software. Whether we permit end-user license agreements or any other practice to absolve people of responsibility for what they do. It was good back in the day when they were trying to promote this industry. But the industry is pretty mature now. They're making a lot of money. Do we need to, give them a shield from that liability? That's already been happening. Finally, through the FOSTA-SESTA legislation regarding how the online companies were using a legal shield to protect them from supporting or vending child sexual abuse and commercial sex services. And Congress finally said, no, we're not going to let you escape accountability for that anymore. And on one hand, it's been relatively effective of shutting down that broad activity in commercial sex abuse. There is some concern now that what it's done is it's driven it underground, which makes it even harder to regulate and to protect people. But that's another issue. But
It's another issue, although it's a very important issue, societal. And what I want to do now is take a few minutes for questions. Then I have the rest of the questions, but I don't want to wait till the end to have all the questions. So we'll open it for questions. And those of you who came late, there is chai and there are some food there. You can use also this time to grab something. I had my chai, and please, we'll open for questions. But be brief rather than lecturing us.
That's our job. Is it? I guess you're the cameraman.
Oh, yeah.
Is it possible that when somebody asks a question, we can capture them on video?
Okay.
Because
You wanna? Okay.
Hold
Who's
you
gonna
accountable.
ask first?
Would you agree that many of the disclaimers of liability would, if tested, be unenforceable? There's a long history in American law of so-called waivers in many instances being held unreasonable because of the context, because of the size of the print, or because of the opportunity to opt out, because of the really. And we're in a situation when we're asking today about specific questions about liability. They haven't all been answered yet. It's pretty new.
Right.
And the law is common sense, except as modified by statute. And the legislatures haven't done much acting yet.
and thank you. And your name, sir, is
Herb?
Thank you, Herb. Another recovering attorney. The by and large, the EULA's end-user license agreements and shrink wrap licenses from the earlier days, those have all been upheld, except in cases, as Herb points out, where they just got so extreme that a court would say, this is abuse of contract, abuse of copyright. We're not going to uphold it. Thus, in fact, even if you didn't click on the I do not agree to surrender my soul button, the court would probably not uphold the company getting your soul. But those are few and far between. The seminal case back, I guess, in the late 90s, Pro CD versus Eisenberg, up the United States Seventh Circuit out of Chicago, dealt with exactly that issue. The court said, no. When you agreed to this, you're held to the terms of the contract. If you didn't agree to it, you could take it back and get your money. But you're tied to it. Very, very tough. The Zeidenberg case was difficult because ProCD had spent millions putting together a telephone directory of all the phone numbers in the United States. And they were doing well with it. They're selling it as a CD set for businesses. Zeidenberg went and bought one down at the local store, ripped every one of the CDs into an online file, and began running his online service, telephone number. And I mean, the judges, I'm sure, were thinking, well, this is just wrong. And you don't like those hard cases coming up because then you're going to get a hard result. And pretty much every circuit, federal circuit in the United States, has pretty much gone along with that. Most are not quite as extreme as our colleague here points out, but you're still kind of locked there.
Let's try to move forward, but I think that this kind of answered your question. There is a question from the back there. Can you identify and speak loud?
And your name is?
My name is Vivek, and I also own a tech consulting LLC. And there's something that I've recently been researching on, and that's called like generative engine optimization. There's just like SEO in terms of Google searches into AI, where you search like top tech consulting LLCs in Louisville, and your name pops up. So that's the SEO in AI, where you search for any services in AI. And related to that, there is one file when you make your website that's something called robots.txt, in which you allow some of the web crawlers, even like OpenAI and Google Gemini's AI crawlers, which they use to get their knowledge base. And you allow those bots to like crawl your website to get all the information. And nowadays, people are not just focusing on traditional SEO, but they're also focusing on getting their ranking up in the generative search. That's the generative engine optimization. But since you allow the web crawlers to go through all of your website and all of the pages, what are some privacy and security concerns related to that?
Thank you.
Thank you. That's a tremendous question, which is probably worth several law review articles. Because it's a huge unanswered question. We have, and it goes all the way back to the early days of the World Wide Web. You put up a HTML file without any security up on a web page. And it's simply kind of been assumed that you're letting people look at it. Because access to a computer and a file without permission is a crime under US law. But we tacitly said, well, this is okay. You put it up there so it can be accessed.
Mm-hmm.
That's pretty much the attitude now. If you wanted to block people getting access to it, except under, say, certain conditions, and to keep the search engines from indexing it, robot.txt file, put it in there, and it should stop.
Okay.
But if it doesn't, I think you've got a good case that's telling the crawlers you do not have permission to scan this page.
Correct.
But you did it anyway. So there has been there've been a whole handful now of copyright lawsuits regarding training data for these new generative AI models. And they started to go against the companies. One or two of the first ones went with the model designers saying, well, this scanning is fair use, so it's okay. And that, to a certain extent, is defensible. Because we still haven't got a handle on what permissions we have to go out on the web anyway. But if you go up against confirmation document which is protected, that's not fair use. What's begun to happen, and this is all happening in U.S. district courts out in California. Justice Breyer's brother just has weighed in. Another judge up in San Francisco, has weighed in and ruled for the AI company. But in the opinion, he said, you, the plaintiff, raised all the wrong arguments. He said this and this and this then you would have had a good case to hold them liable for scanning and using your materials to train this model. The big AI companies have begun to settle the big suits, especially with aggregated groups that represent, say, booksellers or book copywriters.
Yeah.
The book copyright has been one of the biggest ones that I've followed myself. And what if I am only writing an opinion article and I say copyrighted, but I put it on my website?
Even if it, under American copyright law, as well as other countries, even if it's copyrighted, you have control over who copies it.
Yeah.
But there is also a doctrine called fair use, which is that if somebody copies it and reads it for a semi-non-commercial educational purpose, like pretty much everybody who scans the web does, then that's okay. And that's an important idea, because if you were to start saying every access to a file, an HTML file, was a potential copyright violation, potential privacy violation, then you'd shut down the whole system, because then everything would be barred.
Let's have one more question and I'll get back to ask. Thank you so
Thank
much.
you. Thank you.
Good question.
Other
Tough
questions?
Yeah.
Tough question. Why are you asking all tough questions?
I think tough people ask tough questions. And tough people answers those. So,
All right.
thank you.
Yes.
One more question. We need to give him another tough question.
Oh, easy. Sure.
No, you don't have any? Okay.
Yes, sir.
What about the,
Wait, your name?
I'm Joe McMillan. What about this free speech fiasco going on now? How will that affect AI?
Which free speech fiasco? We have a bunch of them now.
Well, that's what I'm talking about. We have a bunch of them.
Okay.
Are you relating to AI generated speech or AI generated videos, for example? Because these are very interesting topics about how free am I to mimic someone
Yes.
Yeah.
and with AI. Maybe would that maybe he'll give us.
Video, audio,
Yeah.
the whole
Maybe-
nine yards.
Maybe you'll give us some guidance there, because we're having fun with that.
Well, see, okay, so he gave us like 3 or 4 law review articles. That's 5 or 6 law review articles right there. And it's one of the toughest points, certainly in the legal community, because all the traditional doctrines are starting to jam up against each other. And a key point to remember is back in the early 90s, one guy said, on the internet, the First Amendment is just a local ordinance. Free speech laws are so different everywhere in the world. The United States laws are the most protective of free speech. Even if you go to Europe, that really gets limited, usually with criminal penalties to it. So keep that in mind, because if you ever want to visit Europe or Turkey or wherever and said something you shouldn't have on Facebook, they can stop you at the airport, take you away. But I'm sorry, getting back to that, the technology can both protect speech, as you pointed out, also do a lot of damaging speech. And so the traditional laws regarding regulation there would still apply. What becomes the challenge is the practicality of anything to protect you from harmful speech. And I'll let you all think about what kinds of speech could hurt you. Yes, sir.
You know, I want to give an example. I'm a football fan, and a bot came and put on Facebook that Donovan McNabb had died, and had a picture of him, looked just like him. And I said, I don't think he's dead. He's not that old, you know. So I went and looked, and he's alive, and he's a businessman in Philadelphia. But on Facebook, it had said that he had a picture of him and said he is a businessman.
That's it gets worse from there, because the technologies within image generation that generative AI offers can let you do a lot worse than doing a fake headline of somebody's death. And unfortunately, in this whole area of what's loosely called revenge porn, ex-boyfriends have been taking advantage of that to do really wrong things to their ex-girlfriends. But one of the most extreme boundary conditions for this actually involves teenage males. Those teenage males, sorry guys, don't have a lick of sense. And they were using these systems, using these systems and taking pictures of girls from their high school yearbook, and then doing nasty things in terms of image generation. Which, by the way, and God, I kind of think these boys don't know what they're doing. Because if you do take a real person's head and you create a pornographic image with it, that qualifies as child pornography, which has huge punishments now in the United States. And even if they chose an adult to do this, the teacher you really didn't like, that's something we call false representation. It's a privacy violation. But then, okay, maybe they won't prosecute you, but they'll try. But you're liable for civil damages. That teacher can say, "You embarrassed me. You pay me $100,000." And what's the kid's family going to do? In some ways, this is a repeat of what happened with copyright violations 20 years ago. When the copyright groups were suing everybody in sight for downloading music, which they shouldn't have. They were going after 12-year-olds. So should the 12-year-olds have known better? Back then, probably not.
A small question related to this. Is a computer-generated video a speech or a artifact? Is free speech goes all the way to artifacts or physical things? Because this is an argument that we hear today,
Sure.
particularly related to other actions. But where does the line stop?
These good, difficult questions. Well, all right, I want to do it this way. I'd like a show of hands. First, those who think it's not speech, and then secondly, you think it is speech. Or how many of y'all think what he just described is not speech?
Because it's computer generated and it's not.
Alejandro's the only brave person here. Nobody wants to
You
go
think
on
it
record.
is speech?
It's not speech.
Should not speak.
He said
It
it's
should not be protected.
Okay. How many of y'all think it is speech? That's subject to protection. Okay. A few more. Ladies, what's your opinion? Don't just sit there. Anna, what do you think?
Sure. So,
A good response. So at least the speech folks seem to have the majority. Yes, it is speech, and there's a whole line of cases that have defined code, and now the output of these systems, particularly the online social media companies, as speech. So it is subject to the protections for speech in the United States, which again are huge. But because people watch too much television, there are limits to free speech, even in the United States. And people that don't abide by those limits they hurt people, and then they become accountable to people they've hurt. This was a whole series of litigations begun. The recommender systems, various online social media services, have been sued twice, big cases where the recommender systems were allegedly involved in supporting terrorists, including terrorists who would then bomb cafes in Europe and kill a bunch of people. Are the recommender services responsible for that? The two cases that have come up so far, gone up to the Supreme Court, have said no. Under the current legislation that protects them from speech generated by others, they're not responsible, even for when this is used by bad people to get speech out. But then a case went up and pretty much pointed the way, saying, if a system, an online service, uses a recommender algorithm, uses an AI system to serve up content to people, that's no longer just the speech of others. That is an editorial curated comment by the company, by its AI. And that is something for which they can be liable. What has happened, y'all have seen this, it's always teenagers have committed suicide over content that they received through the recommender system. The poor kid, oh God. The challenge was to see how long you could asphyxiate yourself. And she killed herself. Why? She got that from recommended content from the social media company.
Let's move to something more positive. Look at the future.
No. Nobody hires a lawyer if it's positive.
Well, a lawyer can tell us how to, okay.
Keep it positive.
Because you highlighted something very important with the man in the loop, or the human in the loop. No biases here. Kept saying he when you referred to your boss, and it kind of irked me. But
My boss.
no, I mean, so let's look at the human in the loop idea in the AI, because it shifts liability in some sense to the
Yes.
human, and that's a very important. So if you are designing a system and want to maximize the benefit and shift the liability from the software people, would you insist to have the human in the loop, the doctor, the banker, the insurance agent, the educator who is grading? I mean, what would be your ideal balance in a legal perspective?
Unfortunately, that's a brilliant question. Why do you do this to me?
No, it's a normal thing. We're working with physicians in some AI things, and we're working with businesses to extract knowledge from their information. And where do we put the real liability in our design?
If it was my software product, I would insist there be a human in the loop. And I would even put in, and they've got to be trained in this so they can actually make determinations when the machine is messed up. Just like the radiology AI systems. Have a trained radiologist who looks at it. Why do you think people might not buy my product? Hiring a person is more money. They want to do it on the cheap. So we want a product that says, oh, we don't make mistakes. You don't need a human in the loop. It'll go right through and everything will be fine and life will be good. And we've had a number of instances where that was the model that was followed, and a lot of people were hurt. And of course, if it's a government doing it, the government may or may not ever acknowledge
No, we have military systems too that has an intelligence in the loop, and we know that some fail. I was by chance chatting with someone recently about a system I'm familiar with, which is deployed by the Navy, and they have a missile system that shot in 2 cases, was in the news.
friendly fire.
No, it was not friendly fire. Was really they didn't like the other guys, but it was not intentional, and that's the issue. And it still made bad news and bad thing. And this system, I happen to be familiar with its very old version. We worked with the Navy way back, but there was no man in the loop in beyond a stage. And once the man in the loop is out, it just.
There is, under the European AI Act, unless you apply one of the exceptions, that kind of technology is forbidden because it can kill people. And secondly, You don't have enough reliability in the system to justify its deployment. There is a related example from the 80s, 70s. The early warning system of missile attacks from Russia, computer controlled, generated an alert that the United States had attacked attacked Soviet Union. So naturally, they're responsible. We need to get our missiles up and back at them. The commander then looked at that and said, "That's not right. Something is wrong." So he said, "No, don't alert Missile Command. Let's start calling people and checking it out." And sure enough, the alert through the system was false. Came close to starting an atomic war, and we wouldn't be here talking. But those are the risks if you take people out of the loop. In the United States, state of Michigan had an unemployment insurance compensation program. All of us who work pay money into this fund as insurance. So when if we lose our job, we will get paid money to survive until we get a new job. They decided to automate the system under an algorithmic model developed by SAS. And how many of y'all have used SAS products or SPSS? Some of those, yeah.
So SAS is different.
Yes.
SPSS was bought by IBM. SAS is still a standalone company, North Carolina.
And the coding was bad, and it started identifying, like 5,000 people were identified as having committed fraud against the unemployment compensation system. In Michigan, if you're found to have committed fraud, you have to pay back everything that you got. But even if you didn't get anything, you were fined. You had a penalty of 4 times the amount you received or the amount you claimed. And the system was so bad. It was even bad on notifying people about this. So people would suddenly find their whole savings accounts seized, pay off these huge judgments they got because the machine was wrong. People were being evicted. They were having to file bankruptcy because all their money was taken away. The era, this was almost, none of you would ever have made this coding error. One of the internal algorithms to determine if they cheating, if they were making a false claim, because it was pulling data from multiple sources in government, taxes being primarily one of the major sources for income. It would pull data from the monthly tax reports. But the algorithm, instead of saying, okay, money this month, no money this next month, and they applied the next month so they're due their benefits, it did an income averaging over the 3-month quarterly period. Who knows why? But that showed then when you applied for benefits in that second or third month of the quarter, it shows that you had income. So you are committing fraud. Want to guess what the error rate on the system was?
100%.
100%. You're cynical.
Yeah.
92%.
But let's go to the next step.
But just in closing, so this was clearly a cock-up. And Australia had a similar system, which was equally bad. They finally said, we're going to shut it down, went to federal court, and I think one group of people got like $20 million in damages. So it can be financially significant, yeah. But I'm also willing to bet that all of those government officials early on were bragging about how smart they were in implementing an AI system to make it all good.
Let's go to one more question, then we'll open it for people. What's your advice for people who are in computer, people who are in law, people who are working for career-wise? Do you want everyone to study law or do you want every lawyer to study computer science, or every business person to study both? Uh, what's really your advice in terms of helping people with their careers to be have a balanced and era of AI for these few people who are in the future? What do you think? What balance they need to?
First of all, don't go to law school. I do not want the competition. But you need to be aware, like as you would for anything, you need to be aware of the legal environment within which you're working. Very highly contested area. Result, the course on law and ethics that's being taught in computer engineering here at U of L, it's the only undergraduate program that I know of in Kentucky. And it's the minority of programs in the country that do that kind of training. And it still had objections in the department.
Yeah.
But at the same time, like the guy who was teaching software engineering, closing course, fourth year, he said, the students that took your class all are much better in terms of incorporating those concerns. They're designing a solution for the class. So I think it's something, if only one course, I'll write a book and you can buy it and read it. But it's something you need to be aware of so that then it moderates what you are doing. But as I said earlier, we've also told our students, working in a human environment, don't call out your boss in a big meeting. This is a one-on-one discussion you need to have with them. And if you're truly litigious, have all your points out, then you email all the concerns and then you go see him. That way, at least you're on record of having told him
Or her.
or her.
Okay.
Sorry, ladies. Sorry.
We want to make sure the young ladies know that they'll be the bosses of the future.
Yeah.
Right.
Women
Because
make fewer mistakes.
that will, yes, that will save the world, actually. But no, that's a good point, is where do you get the balance between trying to prove your point and have a legal trace that you did it, versus and one-on-one in a world that people lack trust these days. Many people will not trust their boss, and some will. I mean, so it's a weird balance where you say, go talk to them, or first send them an email before you talk to them. That's an interesting way of. But trust and legality don't go together. I mean, because I'm from the generation where we have a nod, we have an agreement. We didn't have to sign anything. It became worse. You had to have a handshake to have an agreement rather than a nod. Next, it became you have a small piece of paper. Third, now it became many lawyers on both sides.
And once the lawyers get involved, it just goes to hell.
But that's where the balance of trust versus legality becomes interesting.
But it's also where the knowledge of those issues, even if you're a computer professional, but you know what you need to do. At least you know when. Then we call in the legal staff to say, let's look at this before something gets deployed and somebody gets. We also tell all the students in the class this, and since all of you are once you've got your PhDs, you're going to go out and make millions of dollars in industry. Humana's hiring, so keep them in mind. But we also tell them this: okay, don't just look at the money, don't look at the paycheck. You need to do your due diligence on your employer, on the company you want to work for. Make sure that it's a company that if you say we've got a problem, they'll listen to you, as opposed to a company that says, shut up, I don't want to hear that, go back to work. And it just rolls along and people suffer because of it.
Let's have a couple of questions because it's like one now, and we try to keep people within the lunch hour period. So let's just have one or two questions if they are brief.
Since I've been disrespectful to female contingent here, why not, let's have a question from you all.
Any questions? Okay, no, we'll get the first people who didn't ask, then we'll get you.
You know, we were talking about liability.
Uh-huh.
If AI hallucinates, still liable?
How many of y'all have used a generative AI tool? Raise your hands. Go ahead. And just for the record, everybody raise their hand. How many of you, when you use that generative AI tool, had to click I accept? And the system said, these are the terms and conditions for using our tool. Which, remember the EULA we talked about? Within that I accept document is, we're not liable for anything. Understand this is experimental, erroneous. You cannot hold us responsible for anything. So once you've done that, and it hallucinates, if you're the one that's hurt, well, they're going to hold up the piece of paper. Sorry, you agreed to this.
And it does hallucinate. We know that.
Yeah.
And they admit it. But so what? You get the best out of it. That's why the human in the loop. I think, just, did you have a
Yeah,
question?
it was also about like if have someone that uses AI that requires the liability user that has used that AI to bad thing for a company that doesn't have any type of restriction to that AI.
It's the person that used it, entered the prompts, got the response, and then reused that. Even though end user license agreement said you can't trust any of this stuff. Agree that we are not responsible for anything. But that said, there is another area where you use the generative AI, you do something with it, then you hurt a third person. Did not click on that EULA. Then, depending on the law of a particular jurisdiction, that third person can now come after the generative AI company because it gave bad advice. Because it's going to primarily come after the person that used it. But you can still try and get at the generative AI company. Who do y'all think is probably the poster boy for AI liability in the United States? Close. Elon. Because the Tesla models all use algorithmic control systems for deciding whether they're going to go drive down the road or drive into a truck. Every user. How many of y'all own a Tesla? I don't want to offend anybody, but I know Nora's got two. Yeah. But when you buy a Tesla, you agree to certain things, including you will never take your hands off the wheel. You will always be in control of the system. You are the human in the loop. So when something bad happens and you wipe out a family of 5, well, it's not our fault. He didn't have his hands up. He wasn't doing what he was supposed to do. But well, here's the kicker. In the cases where the guy, sorry, but it's always a guy. Guys screw up. It's such a huge rate. Where the guy has run into a truck and killed himself, family's out of luck. He agreed to be in control at all times. But when he went out of control and killed a family of 5, that family of 5 was not a party to the contract. And their claim is, it doesn't matter that you told him to do this. What you did in your sales literature, in your systems operation, all encouraged him to use the car without keeping control of it the way he should have. And people died because of it. Because there's no waiver for that family, their heirs. Tesla is responsible. And those cases are now being litigated and are going forward. The first cases were when the person that bought the Tesla killed themselves. Now they're starting to kill other people. And those other people are saying, no, the way you marketed this, the way you sold it, you're inviting people to drive dangerously. That's where we're going to start seeing liability.
I think we'll stop the formal discussion But I encourage everyone to stay around, connect with others, and maybe we have some more food. Please join. And thank you so much. Thank you.
For your question. Thank you for not throwing things at me. That's the worst part of any presentation. People start throwing stuff.
So liability and having to in your perspective.
That's the first